Hi everybody, welcome to my channel, Life, Law, Bin. So how did your journey at the University of the West Indies, Cave Hill, begin?
Now about teaching. So I would have been then consulting with the Impact. So there was a project, Impact project based out of the Law Institute Center. So I was there doing some work. And then I had always remained close to the university. So I had been the vice president of the Law Society and I was a mooter. And so I'd go back to assist with mooting. And even when I was in Trinidad, the year after I went to Trinidad, I assisted the moot team at law school, and I felt rather conflicted when the KFL team came down. But yeah, over the years, then I'd maintained a proximity with the faculty, and then there was a vacancy for a tutor in human rights, and so I started tutoring human rights, and I had the kind of uncanny luck that hard work allows and there was a lecturer who was slated to teach gender and the law. And that year, she was unable to teach it. And so, at pretty short notice, I get a call. Would you be interested in teaching gender and the law? Now, I'd done gender related courses, gender and the law related courses while I was at Warwick. And while I was at UE, I'd had the good fortune to engage with many feminists on campus, whether as students or as lecturers. And so I'd been in the space doing research. And obviously, there was now this very different dynamic as a man going into teaching gender and the law, not for me to the extent then that I come to gender and the law with my own gender and needing to address it. But there was this kind of, it had historically been taught by a woman. And so there were interesting dynamics there. And then I would have taught law and legal systems for 1 year. And then there was a research fellowship vacancy, and here we are.
Now, you seem to have a keen interest in research. Do you think that this was inevitable for you to end up in academia?
Yes and no. Um, I knew that, I think maybe my first year at the bar, I felt as though I wasn't fond of exclusive academics. Neither was I fond of exclusive practitioners. And so I knew that whatever I did, I wanted to be between the two. And so a lot of my work, like currently, I'm the chair of a co-chair of an organization called Cari Bono, which is a pro bono network of attorneys. And a lot of my research interests around public law, that's directly feeding into litigation. And so there are kind of luxuriant times when, as academics, we get to sit and think on something for months in a way that the rigors of practice might not always permit. But then it's how can that knowledge then be mobilized into improving the lived realities of people? And so a lot of my work is rooted in that sort of conception that yes, I'm academically interested in this, but this isn't knowledge for the pure sake of knowledge, although there's value in that. It was rooted in those linkages back to practice. But I also knew that practice, the kind of regimented nature of practice, and particularly firm life, that I didn't feel as though it was then for me. And so I was happy to have this space where I could dabble as much as I wanted to, or as little as I wanted to. And but I'd had a have a love of research for the longest. I enjoyed being a researcher at Debating Society. at college, and that sort of, I suppose, what kind of was different for me as an undergraduate student doing or at the level of CAPE, it was I was always so busy that I'd have to set a little time aside when I would cover what we'd done in class, but then there were other things that I was interested in thinking a little bit more deeply about. And so I knew that I always loved research. So that on one hand, yes, but I had to figure out what that arrangement would look like.
You made mention of something quite interesting there. I think it was Cari Bono. Is there
Yeah.
any way that students, I don't know, at any particular level can get involved or get to know about this opportunity, or attorneys recently called? How can they get involved?
All right, so this is an unintentional opportunity for a plug, but thank you very much.
No problem.
So we're really in the space of transitioning Cari Bono. So there was a UE rights advocacy project that was involved in strategic litigation. Out of the URAP project, then came this need for a network of attorneys that would be available to address the needs of inadequately served populations, and hence Cari Bono is born. So I was part of the research at the level of UE when I was a student for URAP, and now as with Cari Bono, we're soon going to be launching a couple programs. One of them will be our Cari Bono Fellows, which will be for university students who are interested in both the research dynamics, but also I think for attorneys that are moving between the law and the development sort of practitioner space, that there are a range of skill sets that you also have to manage. So grant writing, there are very few law courses that give you any instruction as to, well, if you'd like to fund the strategic litigation that will take 5 years, then it's going to need to be funded. How do we go about that? Project management, when you are dealing then with a regional expanse of attorneys and projects, then that sort of key attention to project management becomes really important. So that for the Cari Bono Fellows, they can be paired in a number of different areas. Our website will soon be going live, and once that is live, then we'd be in a position to kind of take direct inquiries there. And then for our young attorneys, we've got, in partnership with the Caribbean Vulnerable Communities, they have a program for what we've now referred to as community legal liaisons, which will be our young attorneys, usually less than 5 years, call, who would be interested in working with host organizations who may also act as hubs. So you may have an organization that's working on gender-based violence, and that attorney is then predominantly catering to the needs of clients linked to that. But where is that's a singular organization for which there is a range of other organizations that might be interested in accessing legal services, then it acts as a hub. And so, yeah, that's one of those really kind of fortuitous things, and how things connect. The all of these different over involvement in civil society at Harrison College and UE, and continuing to be a part of civil society, and then the legal dynamics, and then the academia, they come together really nicely in Cari Bono for me, for example. And so I find that highly fulfilling.
Yeah, and I definitely think that the reason I asked about it is I think it will be an invaluable opportunity for law students and young attorneys to seize. I think any experience is definitely necessary. So that's why I asked about it. And I know people are going to be interested in when that website goes live. So I'm sure you'd be bombarded, for lack of better terms, with lots of inquiries about it. Now, given that you are a lecturer at UE Cave Hill, I think it would only be befitting for me to ask about your perspective as a lecturer as it relates to assisting students get into grips with critical analysis, how to get the best grades possible, what is expected of them, what a marker looks for when he or she picks up that script, the level of detail and the level of analysis. Do you have any points or any advice for law students?
Sure thing. And this varies dependent on one of the first things I'll say is that students have to be adaptable. And so my recommendations, for example, that may differ from another lecturer. And likewise, your lecturers' marking styles, what they're looking for, that may vary across courses. And so kind of being attuned to those nuances so that in my courses where there's some courses that I teach that are heavily socio-legal. And so we're now thinking about law and the way it functions, its relationship with power, etc. That's a very different type of inquiry than when we're trying to understand the ways in which judicial review functions. And so how do I establish locus standi? Is this a case of bias? The technical rules surrounding that. These are two vastly different approaches. And the worst thing you can do in adopting in my socio-legal course is then to just come and say, I'm giving you nothing but doctrinal and you will take that. And so being able to know the demands of the course and the varying purposes of these different types of knowledge. And so for practitioners in my master's course, the socio-legal, they're just like, why are we doing this? I want to know how this works in the case. And it is only after we've done the socio-legal, when we come to talk about the doctrinal stuff, that it becomes self-evident, these are questions that are larger than law. And if I only have a legal understanding, I don't have the tools or vocabulary to expand the law, because the law isn't a closed system. It appears closed through its vocabulary, but when we begin to talk about concepts in the human rights field, when we go back to human dignity and to ideas of constitutional morality, inevitably we're talking about something broader than law. And where increasingly a number of law students do not have either a previous degree or are such good law students that they do law and nothing but the law and don't get involved in many other activities, then the sort of widened worldview that I think benefits analysis may be missing. So beyond that, kind of practical tips, then I think one of the core components for me is for students to think of reading, of legal reading as a skill that they must develop and not something that I've been doing for the last 20 years. And how dare you tell me that I'm not reading properly, because there's a different type of skill that becomes necessary. And the good thing is that there are texts about this, but I often find that I can make the recommendation, this is how you should be approaching this, and I'd suggest you look at this material. But inevitably, when if I'm teaching gender in the law legal systems, that's not the course itself. And so I can't dedicate the sort of time that I would want to, where we're going to annotate a document together, we'll integrate it. But there has to be a sort of reasoned self-reflection about the essential skills of our craft. And so paying attention to your reading skills, paying attention then to, if you're going to be mooting, mooting is not just getting up and talk. And students have to then be willing to go that extra bit in getting the foundational tools. Once we've gotten those, now as it relates to critical analysis, again, that depends on the area that we're looking at. Frequently, we're examining the gray areas of law, where it is clear that this is the rule and the rule applies. That's usually going to be your 1 or 2 mark question. Whereas if we are now interested in thinking of novel possibilities of the law, if we're thinking, let's say, in the context of our constitutional instruments in the region, historically we've said You need to be directly affected in order to bring a claim. We're now then thinking of what do we do with, with organizations? What do we do with the citizen who says this has nothing to do with me personally, but it affects me as a Barbadian or as a Jamaican, etc. And violations of the Constitution just can't fly. It's in those sorts of gray areas that the widest range of thought and development becomes important in demonstrating your analysis. And so students who then end up majoring in the minor and minoring in the major, I find that that's one sure way to not do well in dependent on in certainly in our public law areas. So that if we're thinking then of the development of bias, and we're thinking through the ways in which the historic tests have developed and the new possibilities, you have to have a firm understanding of the foundations, but we want you to be thinking about the possibilities as well. I'm a bit, this kind of tension then also for students between what is the law now, what is the history. A lot of students do not care about the history, this is the rule now. But again, if I, as a not very good mathematician, I knew that my math teachers were interested in the work in. And so that's often what I want to see. How are you demonstrating the ways in which your analysis has developed so that the rule, if you correctly state the rule for me, okay, yes, you know the rule, but then I'm not sure that the policy frameworks, for example, that may underlie it, the reasons why the law has developed in the way that it has, that you are able to grasp that, but also then that becomes important for its predictive value. Yeah.
I think this is all very interesting because I know, just casting my mind back to the LLB stage, you go, you listen, you recognize all the time, the buzzword is critical analysis. Critical analysis, this is what we need. We need causal links. I was hearing causal links being thrown at me from debating days at World Schools, debating with Mr. Applewhite, saying causal links. So it's something that's recurrent all the time. But I think the difficulty with students is, trying to find that way to put their voice into their work. Because most of us say, well, sir or ma'am, I don't have any doctorate, or I don't know enough about this area to even, place my voice into the discourse. How do I balance what X says with Y, and how do I put my thoughts in it? Because I know with law, I still need to support what I'm saying. So I just can't rate it and say, well, you know what, I think this is right, and full stop. So I think a lot of students struggle with getting the linkages right, because we move from a more descriptive style of assessments and being able to score the top end of the marks just by doing that, by knowing what the rule is, and maybe doing a little bit of application. The best students may be doing a little bit of application to then coming into a world where it's a lot more application. So I think, as I'm saying here, the causal links and what is analysis always seems to be the struggle.
So there's this really helpful text, They Say, I Say. And as a lecturer, I'm often then conflicted around, because it can function almost as a template that allows students, for example, to be able to better compare and contrast, to synthesize perspectives. And the kind of risk of giving students templates is that they follow them slavishly. But it's an exercise that provides this very practical, reasoned way of engaging in conversation. And so that text frames academia, frames writing as conversational. I am entering into a room where people have been talking. And how do I then listen to hear the commonalities of their voices, to hear the tensions in their statements? How do I see beyond what are obvious tensions, but nonetheless find similarities. And so that text I found very, very helpful. They say, I say, um, as a mechanism for students to work through. Books like Learning Legal Rules, there are a range of texts that I think the good student, the good student will go beyond the what we can give you in class. And so, and this is also true then of the good attorney. The good attorney that studies his or her craft, you're going to spend a bit of time reading about advocacy, not just engaging in the blood sport and practice of advocacy, but also then learning from the many experiences that have gone before you and thinking, okay, how do I bring this in? Now, coming back then to the challenge of students finding voice. Um, I say to my students that you are in this kind of odd purgatory where, on one hand, you know, your individual thoughts alone are less significant than your thoughts marshaling other materials. And so that your perspectives, I've said to students, you have to distinguish being opinionated. And so you get students that come in and just, this is a most ridiculous proposition of law, da, 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 as then compared to building out the analysis, engaging in, okay, this is a scholarly literature on this. This is how judges have spoken about this outside of court. And this is then how this case has later been applied, fusing those to then build your perspective. And so those are the foundations of your argument, rather than your argument just standing up on its own and hoping that the wind don't blow too hard via my marking pen. And so, I think less so than specific rules of critical analysis involves asking the why beyond. Critical analysis invites us to think of the connections and the continuities, and I'd prefer instead to suggest methodologies that students should be pursuing in order to be able to get to the place of critical analysis, what in the literature we may refer to as metacognition, so that students become self-regulated learners. And so that's then where those almost self-help books, academic self-help books, that they become so much more important. But beyond that, I'm personally, if not offended, hurt by students who, I will never tell a student, you cannot pass this course if you did not read the judgment. I know that that's false. A good summary, a textbook, etc., often will allow you to pass the course. But it is through reading the judgments, for example, that you pick up writing styles that you like and you dislike. You see how judges build out analysis. In listening to court arguments, you hear how advocates are strategic in the arguments that they advance. I may have this argument in essentially holding in reserve, and only if it arises in argument, then will I bring it as a rebuttal, because I know that it was a risk for me to just bring it out the block. And so coming back to these basics of meaningfully engaging with the cases and the original text, the primary text, that's madly helpful, because that's where then I think students build up the sorts of core skill sets that will position you better for the life of practice. If you're studying to pass your degree as compared to studying for a profession, then the easier route, that'll get you your degree. My students say C's get degrees, and that's true. But moving then into practice, picking up those sorts of key skills, I think, becomes all the more important.
Well, Rashad, I really enjoyed our discussion here today. And I just want to say thank you for finding the time in your busy schedule to fit in this interview and to enlighten my viewers on this particular area. So thanks a lot for coming and for sharing.
Thank you for having me. I hope I wasn't too chatty. I enjoyed it, and
No, I quite enjoyed it myself, so it's not an issue. So everyone else, thanks a lot for tuning in, and I'll see you on the next video.